Good evening and welcome to our continuous revision tonight. For quite some time now, I've not had the time to be able to regularly meet as I have wished to. But the most important thing is that when time permits, we're able to have some engagement. So tonight, we will be going back to law of contracts. And before we actually proceed, in case you have just joined us for the very first time, there's a particular advice I gave, and I will reiterate that because the purpose of doing this with you, I'm sort of like I'm coaching you, right? I don't see myself as maybe teaching you all over. But what I'm doing, the presumption or the presupposition is that you've all learned this already, but my task is to coach you as to how to go about the preparation. So from time to time, I will remind, especially those who haven't had the benefit of hearing some of the tips that I have offered in the past regarding how you should go about the preparation. So because we are doing contracts, I'll just limit it to contracts. And the advice is that the topics in contracts are not many, okay? They are not many. We can just rattle through them. And very soon, as we start, you'll notice the topics, if you have to count them, they are actually less than 10 topics. So my advice is that as far as contract is concerned, make time, take a necessary book or sheets without opening any book. List the topics, and under each topic, you take each topic one after the other, and then on your own, state the principle. Because contract is essentially about certain rules of law, certain principles, which guide formation, interpretation, and also remedying breach of contract and so on. So you try under each topic on your own, what are the principles? If you take, let's say, offer and acceptance, you start from offer, what are the relevant principles? Acceptance on your own. And as you do that, you must also add the corresponding authorities. That is the case law, or in limited instances, the relevant statutory provisions, maybe as in the Electronic Transactions Act, or the Contract Act, or the Auction Sales Law, as the case may be. You should cite them alongside the principles that you outline. Now, when you do that for all the topics in contracts, when you are done, you take your contract book, that Mrs. Bruna Hammond, or any good contract book, and then you try to cross-check as whether you've done a good job or not. And once you do that exercise, you will get a clear picture of where you are relatively weak in terms of not having proper graphs of the principles, and you need to do more reading there. So that is the best way to prepare. And as I told you, for me, I would like to be the student who does not predict questions, but would like to prepare well on all the topics, so that when he goes to the exams, he may not get first class, but he will certainly not fail the paper because he has prepared very well. Okay, so that is just by the way. So having said that, we will continue with our lesson, I think lesson 9, if I'm not mistaken. Let me see. So we'll continue with our lesson 9. And as I usually do, I do what we call like a question teaser. The question teaser I do just to give us a sense of some of the things that we should be able to do if we have learned the topic we are going to revise well. So this is like a program-based question. And of course, you know the IRAC. And the story is this. I mean, some of you know this type of question before. Brown knows that Wright has been keen to buy his car. On Monday, he tells Wright that he had decided to sell the car the price of 20,000 Ghana cedis. Wright says that he's very interested, but would like to think about it. Brown says, I will assume that you want it unless you tell me otherwise by Saturday. On Friday, Wright meets Green, who tells him that Brown had just agreed to sell the car to Smith for 22,000 Ghana cedis. Wright, who had decided he wants the car, immediately puts a letter in the post accepting Brown's offer. Later that day, however, he has a change of mind and calls on Brown to tell him to ignore the letter. Brown tells him that his deal with Smith has fallen through and that he's still keen to sell to Wright. I'm giving you 2-3 minutes. Apply IRAC, especially identify the area of law and raise the issues. So in 2 minutes time, I will just come back to you. Those who would like to share their answers with us, we'll take them and comment on them before we continue with the presentation or the discussion bit for tonight. So 2 minutes, okay? Right. 2 minutes. Yeah, so as, okay. If we have some responses, you can put them in the chat, or if you want to unmute yourself, you probably take 1 or 2 students and then we come back together. Is anybody ready? You can just raise up your hand and then I will allow you to unmute yourself. Is anybody generous to share his or her thoughts on this teaser? Whose hand is up? Nobody? Okay, so since you don't, okay, let me look at the chat. So we are reading, okay. Or maybe let's work together. Probably that will let us move fast so that we don't waste time and we can do what you want to do and close. Good. So as I have suggested before, when you have a problem-based question, certainly the approach we use is the IRAC, okay? So we need to know the area of the law and also to help us to, if you like, get the issues. Although the area of the law is not mandatory, but it is a good practice, especially as far as Ghana is concerned. A lot of the lawyers or the law teachers are happy with stating the area of the law as well. So I would suggest that you don't ignore it. Although if you go to the UK, some universities, they don't really need it. What that they need is the issues that you are raising. But area of the law, so you read the passage from the beginning to the end. The area of the law will become evident to you. So what is the area of the law before the general area of the law? Certainly we are in contract, but which aspect of contract law you think is implicated or is actually relevant or emerges from the story? Yes. Any thoughts? Oh, you are still reading. Brown knows that Wright has been keen to buy his car on Monday. He tells Wright that they decided to sell at the price of 20,000 Ghana cedis. Wright says that he's very interested, but would like to think about it. Brown says, I will assume that you want it, unless you tell me otherwise by Saturday. On Friday, Wright meets Green, who tells him that Brown has just agreed to sell the car to Smith for 22,000 Ghana cedis. Wright, who has decided he wants the car, immediately puts a letter in the post accepting Brown's offer. Later that day, however, he has a change of mind and calls on Brown to tell him to ignore the letter. Brown tells him that his deal with Smith has fallen through and that he's still keen to sell to Wright. So what do you think is the area of the law or the areas of the law raised by this story? Anybody? Okay, so, let's see first. And what I'm going to do is that I'm going to release all of you, but please make sure that your mic is off all the time so that we don't get a feedback unless, and only one person should have his or her mic on. So Cephas, you can unmute yourself. And
thank you, sir.
Okay.
Please, the area of law here includes offer and acceptance and some areas of postal rule.
Okay, so offer and acceptance, particularly postal rule, that's what you're saying? Okay, so I think that we have, area of law is agreement, specifically acceptance, and then we have, there's another one earlier on, let me see. Ambrose, communication of acceptance and revocation of an offer. Okay. Then often,
sir,
yes. Yes.
Hello, sir.
Yes, Charles.
This Charles.
Yes.
I think the area of law first is offer and acceptance. Then communication of revocation. And then silence as a mode of acceptance. Then the postal rule of communication of acceptance.
Okay, all right. So you'll be very more, you've broken it down, but there's also nothing wrong if you use like the general one and say that the area of law is offer and acceptance. You cannot be marked wrong because as a matter of fact, the matters which are implicated in the story really offer and acceptance. So that is fine. Good. So now let's take like the issues. So the issues, I said that you should take sentence by sentence, right? That is the easiest way not to lose out on any issue. So Brown knows that Wright has been keen to buy his car. You ask yourself, does this actually provoke any issue? Does it? Certainly not. Because what are we thinking of an offer or what? If you know that somebody is interested in buying your car, it doesn't raise any legal question, isn't it? On Monday, he tells Wright that he's decided to sell at the price of 20,000. Does that provoke any issue? Does that suggest any issue? If it does, what is it? Quick. Yes, Cephas.
Please, sir. The issue here could be whether or not Brown has made any valid offer to Wright.
Okay. Okay, that is fine. How else can it be put apart from how Cephas has put it?
Sir, I think this chance, I
Yes,
think whether
Charles.
or not there is a binding agreement between Bright and between Brown and Wright.
If you say binding agreement is not wrong, but I would discourage that because if you say binding agreement, you are still at the too general, it's too abstract, But then if you break it down, certainly you know that agreement, you need an offer, isn't it? So if you can come down to using the way that like Cephas put it, the sense there is that we are asking, the essential point is that has Brown made a valid offer to Wright? Has he made an offer to Wright? I think that is the essential question. And now that can be formulated in various ways. Of course, there are various ways of speaking. Some will say whether, as in the Cephas or somebody put it, whether or not Brown has made an offer to Wright. It can also be put in so many other ways, but the essential point is that however you formulate it, however you catch it, you must be thinking of what? An offer. So at this stage, you just be at the area of the offer and invitation to trade at that particular sentence. You cannot go to any other particular area. Yeah, okay, so somebody has made the formulation, whether or not Brown's offer constitutes a valid offer. Okay, I think that is also fine. Good, so let's move on. So we have one issue now. We haven't finished the passage. Wright says that he's very interested, that would like to think about it. Does that suggest any issue, or we should just ignore it? Hello? Yes. So I'm running the class with only Cephas, eh? Okay, so Cephas, go ahead.
So I would like to try that.
Okay.
Whether or not Wright has made an unequivocal acceptance to the offer of Brown.
Okay. Okay, so you're thinking of whether Wright has accepted the offer, isn't it? Or has been, okay, that's fine. Can be put in other ways, but at least that is good. Has anybody put in any other way? There's nothing from the chat. Okay. Now let's move on. Brown says, I will assume that you want it unless you tell me otherwise by Saturday. Does that suggest any issue? Does that, yes, Ambrose. Ambrose, please unmute yourself and go ahead. Oh.
Okay, sir. Okay, sir. Thank you, sir. Sir, I'll go with whether or not Brown promised to keep the offer open was binding on him.
Okay. Okay, that is fine. But can it be put in a much simpler, right, and direct or succinct, way? Can it be more poignant, very sharp? Yes. I get what you mean, Ambrose. You're on track, but can it be refined? Yes, I think there's a... Okay, Cephas, you want to have another go? Okay, Cephas?
Listen, whether or not Brown has made a firm offer.
But already, don't forget, we have raised an issue about Brown having made what? An offer, isn't it? If you remember,
Yes,
that
sir.
was like the very first issue. So
yes, sir.
It will not be a good idea to still be framing that issue here. There's another issue which is embedded in this particular statement. I will assume that you want it unless you tell me otherwise by Saturday. Maybe let me give you a clue.
Sir,
Yes.
I'm thinking that he's using silence as an acceptance there. So whether or not Brown's silence until Saturday constitute an acceptance of the offer.
Okay. Okay, that is, I get what you mean. You're thinking along the lines of filters and binding. Okay, that is fine. But what about, is it that unless we tell me otherwise by Saturday? Does that suggest anything to you? So, does that suggest anything to you? Yes, something in the chat. Whether or not Brown's electing to keep the car till Saturday prevent him from selling to another person. Okay, so we are thinking of whether Brown is bound, right? Whether Brown has any obligation to keep the offer till Saturday. Okay. Is Brown bound to keep the offer till Saturday? Okay, I mean that is a fair point. And then someone also raised the issue along the lines of filters and binders, whether Brown can impose the silence as the mode of what? Acceptance by Wright. Or you could also raise the point that what is the legal effect of the silence Brown is trying to impose on Wright? Or you could also be silent on that particular issue, so that when you are discussing whether Brown is bound to keep the offer till Saturday, then you will discuss that bit of filters and bundling as well. On Friday, Wright meets Green, who tells him that Brown has just agreed to sell the car to Smith for $22,000. Does that suggest any legal issue? Does that suggest any legal issue? Okay, yeah, Kwasi, I like how you put it. Kwasi said, whether or not a Brown's prescribed mode of acceptance is valid. Okay, I mean, he's talking in reference to the silence bit that we were contending with. Okay. Now, so the sentence I just read, does that suggest any issue? Wright telling Green that Brown has agreed to sell the car to another person, Smith, for $22,000.
Yes, sir. Yes, sir. This chart, it suggests that a communication of revocation by a third party. So the issue here will be whether or not the contract between, the offer has been revoked by Wright, and the communication to the offeree is valid.
Okay. Okay, so Charles, we get the sense. Can anybody put it any other way? So we're just trying to raise the issue as to whether the purported communication of the withdrawal of the offer or termination of the offer is effective. And whether the purported, I say purported because you are now going to discuss it and resolve it legally. Okay, so Kweku, okay, let me, whether or not communication or revocation by third party is valid. Okay, yeah, Kweku, I think that is also good. Whether or not communication or revocation by a third party is valid. Okay, that is good. So how many issues do you have so far? About 3 or so. So we move on. Wright, who has decided he wants the car, immediately puts a letter in the post accepting Brown's offer. Does that suggest any issue? Does it suggest any issue? Okay, Cephas.
Yes, sir. Please, whether or not Wright has validly accepted Brown's offer by post.
Okay, whether or not Wright has validly accepted the Brown's offer by post. Okay, okay, I mean, that is fine. Is there any other way anybody will put it? Let's go to the chat. Has anybody put anything there? Okay. All right, thank you, Cephas. Now let's move on. Later that day, or you could simply also say that whether the postal rule is applicable to write a letter. Is the postal rule applicable to the right letter? If it's applicable, then you know that acceptance will have been made, isn't it? Don't we come to discuss it. Okay, we have some suggestion, Miranda, in the chat, whether or not a right communication of acceptance by post constitute a valid acceptance. Okay, that is also fine, Miranda. Let's move on. I think we are getting to the end of the passage. Later that day, however, he has a change of mind and calls on Brown to tell him to ignore the letter. Does that suggest anything? Does that generate any issue? Does that suggest any issue? Yes, are we together?
Hello, sir.
Yes, people.
I think it's whether or not Wright communicating to Brown of his revocation constitute a valid revocation of his acceptance.
Okay. Okay. But don't forget, we are moving from a sentence where he sent the purported acceptance in the form of a letter through a post. And having done that, we are told that later on, he has a change of mind and he calls, ostensibly by telephone, to tell the offeror to ignore the letter that he has posted. So does that raise any legal issue? Certainly there should be. But what legal issue is that? Anybody?
Sir,
Yes.
I think it's instantaneous communication of revocation of acceptance.
Okay.
Hello, sir.
Yes.
Okay, so in my view, I don't think that will constitute a substantive legal issue. So when you are doing your when one is doing his analysis on the postal rule, that is when you can bring that in to do your analysis, because the postal rule is said to be effective at the time that the letter was posted. So
Okay.
if he later changes his mind, then in doing your analysis, you have to determine whether his later decision to change his mind will be something that has any effect.
Okay. All right. So now you see we have about 4 or 5 or so issues, isn't it? How many issues? We have about 5 issues. Yeah. So I just want to use this to draw your attention to something that when you have a problem-based question, not only in contracts, right? In any other area of the law, in this type of examination, it is very important for you to be systematic, take each of the sentences in the passage or the scenario, one after the other, and ask yourself, based upon the bigger area of the law that you have delineated or you have identified, do you think that any legal issues, questions emanate from the particular sentence? So if you do it gradually, you will notice that no issue will be lost on you, right? No issue. If the marking scheme, for example, has 5 or 6 issues, you will definitely get all of them. And don't forget, when your examiners do marking scheme, you being able to raise the issues, you get marks for that. Before we come to the stating the relevant principles or rules for that issue, you get marks for that. And then you come to the analysis and application of the relevant rules under the issue to the facts to resolve the issue. Because the issue is a question and you need to answer it. And how do you answer it? You use the law that you have stated under it. You look at the facts. Are the facts supporting or answering the principle that you have stated? And that should enable you to answer the issue or to resolve the issue. So that is how it is done. So we'll have to leave this and on your own think about it. Yeah, so coming back, so far, in our last lesson, on contract, we started a very basic introduction, and we said that we must always remember elements of a valid contract. You must have an agreement. An agreement is usually analyzed by the presence of offer and what? Acceptance. And of course, we also said that every contract, there must be intention to create legal relations, especially if you are dealing with what you call like the simple contract or oral or parole contract, which is not reduced into writing with the seal of the parties. Then there is evidence for the court to be satisfied that, yes, the parties really meant something obligatory. They're not just playing games. And that is why the intention to create legal relation, as well as consideration, is what is important. And again, you must be qualified in law before you can enter into certain transactions, including contracts. So capacity, we'll talk about that. And again, there should be certainty of terms. And that is why the first meeting, I think we talk about how do we even determine agreement, what the parties have actually agreed upon. And you talk about the objective tests, if you remember. We talk about the objective tests, especially so where the parties have not reduced their engagement or transaction into writing. And you need to really ascertain what exactly have they agreed upon. You need to pay attention to what they said to each other, what they did to each other, and use the point of view or the perspective of the reasonable person, or what we call the official bystander. So that is what the objective test is about. If you remember, we talked about it in our last class on contract. Then again, in contracts, you must have, there should be genuineness of consent. You know, at the bottom of contract is, voluntariness. It's about violence. People say freely. And that is why we talk about the pacta sunt servanda, sanctity of contract. All those things are there because contract presupposes that the parties to it have freely agreed. So if there's any question mark about a person not having given his or her free consent, then there's a problem, meaning that we don't have any consent. And that is why we talk about vitiating factors in contract, okay? So vitiating factors, mistake, misrepresentation, duress, and undue influence. So when you can identify any of these as being present, then what it means is that one party or both parties might not have freely and genuinely given their consent. And that will definitely have an implication for the validity of the contract. Later on, we discuss some of this. And of course, finally, every contract must be lawful. So the requirement of legality. You cannot enter into contract which is against the laws of Ghana, against declared public policy. So these are the basic requirements or elements for a valid contract. So the last time, as I said, we talk about like the test of what? Agreements. We talk about the objective test extensively. So we are not going to repeat that, but just to remind you that, as I said, the court will just pay attention to what the parties said to each other, what they did to each other, and then the court will try and use the perspective, that is the point of view of a hypothetical person, which we call like the reasonable man, or the officials bystander. And for that matter, it is not what the parties actually thought. It's not what you thought, in your head, which matters. What matters is what you said and how a reasonable person, official bystander, assumed to be present at the time that you said it or did it, or have understood you to have actually intended and know what you truly intended in your own private mind. So let's keep that in mind. Then we look at the authorities. Then we also discuss offer and then the invitation to treat, if you remember. So we'll go back to the lesson. Look at the various instances in which the courts have had to draw a distinction between offer, invitation to treat. That is when the court have said that yes, something looks like offer. It is not. It is invitation to treat. We discussed that as well. And of course, all of us, we all know the case of NTAC against entry very well. A very recent case given just enforcing what the cases of Manchester against Gibson and also Manchester against Sora, what they tell us. I'm sure you remember that as well. Then I think we were to talk about general offers. And then, yeah, we did. So when we were discussing advertisement, we said that as far as advertisements is concerned, as to whether it is offer or invitation to treat. It is not straightforward. It depends upon the wording of the advertisement. So you cannot just jump to the conclusion that any advertisement is invitation to treat. No, that will be too simplistic and you could be wrong. Now, where the content of advertisement is such that it is, for example, making a general offer along the lines of the things that we read in the case of Carly against Kabbalah Smuggle, if you remember, where a specific act or specific action is required. And then there's maybe a promised reward or something which is promised in return for you doing the specified act or action. Then that means that we are in the realm of a general offer leading to unilateral contracts. And we are not just talking about bilateral contracts, as happened in the case of Partridge and what, Crichton. So let us pay attention to that. And of course, with respect to general offer, the question will arise. Since the general offer, who is supposed to accept it? You know, there has been like that debate. Usually, it is accepted by the person who will do the required act. So just like Gibbons and Proctor, anybody who brings information leading to the arrest of a particular alleged criminal will be given a reward. So that is a general offer to the general public. But ultimately, it will be accepted by the person who will actually go ahead and do what the advertisement is asking for. So let's keep that in mind. Just like, you know, the famous, every student's local and Kabbalah smoke ball, where they say that if you bought the soap smoke ball and then use it according to the prescribed directions, and you still got a certain outcome or side effect, as it were, you're going to be giving compensation of £100 and so on and so forth. And indicated that they had even deposited the money with their bankers somewhere in London for that purpose. And for that matter, the person, anybody who will buy the product and use it and gets the, the stated outcome, that person is the one who will be considered as having accepted the offer. So let us keep that in mind. So my advice to you for purpose of this type of entrance examination is that when you get a story, sometimes questions about general offers or unilateral contract, it may be very simple, right? You get like a very simple story or scenario, but you have to take your time and be systematic. Usually when students are given very simple scenarios, they tend to think that because the scenario or the story is so simple, there's no need to go by IRAC and be systematic. And we just have to just tell the examiner what we think the conclusion or is. No, if you do that, you are falling into avoidable pitfall, and that will let you get a low mark. So all the time, be systematic and go along the IRAC as we'll be discussing. Okay, termination of offers. Offers are not meant to remain forever. At some point, an offer must come to an end, and we know that there are various ways in which an offer may come to an end, including rejection, right? You what do you call it, a counter offer. If I have made an offer to you, instead of you accepting it, you don't accept it, and you introduce a new term, or you try to vary or modify the term contained in the offer, that would not be considered as acceptance by you. That would be considered as a rejection of the original offer by you. So that will destroy that offer. So hide and reject, remember that. Another means by which an offer may be terminated is through lapse of time. Lapse of time, it works in two ways. Where the offer has got a duration attached to it, then automatically, when the stated duration has elapsed, the offer will also have been considered to have come to an end by a fruition of time, by lapse of the stated time. On the other hand, where no particular time has been prescribed to that offer, then the position of the law is that after expiry of reasonable period of time, the offer will be considered as having come to an end. And then what will amount to reasonable period of time, it is something which is worked on case-by-case basis. Among other things, to include like the subject matter of the what is in the offer. So that if you have, let's say, the perishable commodities, which is the subject matter of the offer, then certainly, based upon how long that particular commodity can last, the offer will also be considered to have lapsed when the period has actually come to an end, and so on and so forth. So it very much depends on the particular type of situation that you have on hand. Again, offer may also come to an end through a positive act. That is a conscious act by the offeror. That is revocation or withdrawal. And you made the offer. So the position of the law is that anytime before acceptance, you can revoke it. Cases of Pain and Cave, Woodledge and Grant, so many cases which support that principle. The only exception or caveat is that, you see, at common law, where you have even expressed offer to remain valid for a certain period of time, that collateral promise that the offer will remain binding for the same period of time is not binding unless the intended offeree has provided consideration or has done something to justify why the offeror should actually hold on to the offer for the period that you said you keep the offer. So that is the ratio in the case of Woodledge and Grant. However, in Ghana, by reason of the reform to the doctrine of consideration, as contained in the Contract Act 1925, especially Section 8, subsection 1, a promise to keep an offer open for acceptance for a specified time shall not be invalid as a contract by reason only of the absence of any contribution therefore, unquote. In other words, where you have, in Ghana, where you've given a time period or timeline for the offer, you are bound to keep it till that time. And it will not be a defense on your part if you decided to withdraw it, to say that, well, the offeree did not do anything to justify why I should hold on to the offer till the period that I prescribed had elapsed. No, that is not the case. So let's keep that in mind. And again, where there has been revocation, where there has been withdrawal of the offer, it is not binding. In other words, it does not really have legal effect until it has been brought to the notice of the offeree. And the reason is simple. You made an offer intended for me to accept, so that there's a contract between you and I. Now, if you have decided to take the offer back and you keep quiet about it, how will I know? I might have taken steps and I'm almost at the point of accepting it, but I am quite ignorant that you have withdrawn the offer. And that is why it is a common law that revocation of an offer, termination of an offer is not effective unless it has actually been brought to the notice of the offeree. And for that matter, let me add that when we are discussing acceptance, we have the communication of acceptance by the postal rule, which says that when you have properly addressed the letter and posted it in the usual course, then immediately upon posting, acceptance is deemed or considered to have taken effect. That does not apply to a letter seeking to withdraw the offer. So if you have posted a letter seeking to withdraw an offer, that letter is not considered as having actually succeeded in withdrawing the offer until it has actually reached the offeree. Now look at it. If it were acceptance, upon posting the letter of acceptance, that will have sufficed. That will have been enough for the acceptance to be considered as having taken place. But the same is not true when you are dealing with communication of revocation of what? An offer. If you post it, it must actually reach the offeree. So let's keep that in mind. So look at the case of a Brian against a Vine in Hoven. And again, the question, where communication, must communication be, communication of the revocation of the offer, must it be done by the offeror only? The answer is no. If the offeree can become aware of the fact of the revocation by the offeror through a reliable third party, that will suffice. And that is the ratio of the case of Dickinson and Dawes. Dickinson and Dawes, that where there has been a revocation, it can be communicated by any reliable third party, and that will suffice. So let's keep that in mind. Now, in the case of general offer, that is offers which are meant to potentially bring about unilateral contracts. As far as revocation of that is concerned, it is position of the law that you should use the same channel through which the offer was actually made. Yeah, so if you look at the case of the Shoei against the United States and so on, and then, of course, to some extent, Arrington and Arrington, especially Arrington and Arrington is authority for the proposition that in the case of unilateral contracts, where the offeree, that is where someone has actually embarked upon performance of the specified acts, then the offeror cannot withdraw that. So let us keep that in mind. As I said, I'm moving very fast because the assumption is that we know this already. So we are just refreshing our mind. Now, another point which is worth touching on is what we call like the battle of forms. Although you could have talked about that after acceptance, but no problem, we can touch on it here. So battle of forms, if you don't know anything at all as far as battle of forms is concerned, you know the case of a Battler Machine 2 company against the SLO Corporation. And practically, this is how the battle of forms is. Let's say that usually you have companies which have got their own forms, like standard forms for buying, for making purchases, for doing procurement or requisition of orders. So let's say that the company A has its own standard form, which it will use to order goods from others. And let's say the company A uses it to order goods from company B. And let's suppose that company B too has also got this standard form, which it uses for prospective buyers to fill, so that they use that to do the necessary supplies and all that. So A made the order using its form, and then B signed and all that, and B also made A sign its form, which it uses to make deliveries and supply customer needs. So we have two sets of forms, and each company has got its terms and conditions clearly stated on its particular form. Now, you have a disagreement. So if you go to the Butler machine too, one company has got, if you like, inflation review clause or adjustment clause as part of its terms and conditions. Another company has not got that. So you have a dispute, and then there's this issue as to which of the two forms should be considered as being what was actually agreed upon. So which of them should be considered as, having been the offer, and which one should be considered as being like the acceptance and all that. So that is what the battle of forms is really about. And usually, if you look at the Butler Machine 2 case, the court tried to resolve that using the counter-offer analysis approach. Okay, like the counter-offer, the kind of analysis you saw in the case of a hide and range. Then the court will try and find out, okay, using the counter-offer thinking, which of these two can be considered as having made the offer first? And then the other one, so that if you just suppose the other one by it, and you notice that the other one is not mirroring the first one, and then there's an attempt to vary or modify it, then that will be treated as what? As a counter-offer, and so on and so forth. So look at that. Okay, now acceptance. It's now 10 o'clock. Let's see, a few minutes we can get acceptance cleared so that we leave this area. Now, as we remember, acceptance, is where the offeree has made the final and unqualified assent for approval the terms of an offer. This finality is important because don't forget, when we are talking also about offer, right? Offer 2 requires finality on the part of the offeror. You are the offeror, you would like to get agreement between you and the offeree. So the offer contains your proposed terms, your proposals, which you are immediately ready and willing to be committed, be bound by it, if the other party will accept. So that is the offer. In much the same vein, in the case of the offeree too, his acceptance or her acceptance must be unconditional, unqualified, or unequivocal, definite, or final endorsement to the proposal contained in the offer. And that is why we often hear that acceptance must follow what we call the mirror image rule. If you have like a mirror, you put an object in front of the mirror, you see a reflection of the object in the mirror. And then the reflection of the object is like the image. You see, that's the exact image of the object you place in front of the mirror being reflected in the mirror. So in the same vein, the acceptance must also mirror the offer so that the exact image of the offer should be reflected in the acceptance. And that is why we say that the offeree must not change even a comma or a word in the offer. And were that to be the case, that will constitute a counter offer which destroys the original offer. We know that for the case of hide and range, they be against Insian Antonelli and all that. But then we also know that where there's an attempt to seek information, maybe concerning instrumental payment or some other things, so you are making like a mere inquiry, then authorities like Stevenson and McLean, and to some extent NTHC and NP will tell us that that is not a counter offer. It is a mere or general request for what information. So let us keep that in mind. And again, we also remember that acceptance can be by words, by conduct, or can be in writing. So in a conduct, for example, the case of a broadening against Metropolitan Railway, if you remember, where, there was an offer had been sent, then instead of they signing the agreement, they didn't sign it, they put it in a drawer, and yet they started supplying things or delivering things according to the unsigned document. And later on, when there was a disagreement, the court said that, yes, it doesn't matter that they had not actually written back to say that they've accepted. Their conduct subsequent to receiving the offer was indicative of they having actually accepted. So acceptance can be by what? By conduct. So let us keep that in mind. And then the communication of acceptance, as we remember, the general rule is that acceptance is not valid or effective unless it has been communicated to the offeror. And this communication must be done by the offeree or his authorized agent. So that if you are not an authorized agent of the offeree, then you cannot effectively or validly communicate acceptance. You know the case of power and lead, the interview and then the person who has not been authorized and lead the information to the applicant that he has been successful, if you remember. So Powell and Lee. And of course, if that is the case, then acceptance is not has not taken place unless and until it is communicated with the offeror. So the case of Kofi and Zanyo, as you remember. Then we come to the mode of communicating the acceptance. So where the mode of communication is instantaneous, right? Instantaneous means that as soon as you speak, the other party hears it. So for example, what we are doing now is an example of instantaneous communication, because if I speak, you hear it. When you speak, I also hear it. Now, where that is the case, then the case of Entos against Far East Corporation has established that acceptance communicated via instantaneous mode, like teles, fax, and telegram, and all that, is not valid or effective unless and until it has actually reached the offeror. And if you read the endorsement, you see the analogy Lord Denning will give about the plane which is flying and all that. But an exception to, we have some exception to the rule that where you are using instantaneous mode of communication, acceptance is not complete unless it has actually been received or heard by the offeror. We can have a waiver, and this waiver may be express or implied. The offeror may waive the communication. Like, for example, when it comes to general offers, like the unilateral type of contract, there's what we call implied waiver. You don't need anybody to come and tell you that I'm going to do the required act. What is expected is that just do it, and you doing it means that you have accepted it. Another exception is the postal rule, where the post is the means of sending the acceptance. Then, as we know from the old case of Adams and Linsell, is that acceptance takes place as soon as the letter of acceptance has been posted in the regular way, according to the customs and tradition of posting in that particular area, when acceptance has taken place. And again, where the offeror has prescribed the mode or the means of acceptance, then that is what should be used and not any other means. So let us keep that in mind. And then we also come across the point that the offeror is not permitted by law to impose silence as a means of acceptance by the offeree. But so as happened in the case of elders and man, remember the uncle and the nephew concerning the sale of the horse. And then the uncle told the nephew that if I don't hear anything about the horse, I will assume that you've agreed to sell the horse to me at the stated price. Now, let me add that there is nothing wrong, right, at the negotiation stage for the offeree or for the parties to say that, okay, let us give ourselves up to Sunday. The one will say that, okay, if by Sunday, 6 p.m., you haven't heard from me, then take it that I have agreed to buy the car at 100,000 Ghana cedis. Now, if there is that kind of mutuality. If there's that mutual understanding, then there's nothing wrong. Silence can be a mode of communicating acceptance. So let us understand it well. What is reprehensible about the development in filters and binding is that it was one party, the overall, who was trying to, if you like, hold the overreach ransom that, well, you are supposed to let me hear from you. If I don't hear from you, then my assumption is that you have accepted my offer. Now that is not fair. But it is different where there have been some understanding between the parties, and then the prospective offeree said that, okay, if you don't hear from me, take it that I have accepted the offer, then that one is acceptable and is permissible. So let us keep that in mind. Okay, so we will leave our discussion here. And regarding what we did in the beginning, the question, we have a couple of like the issues. So because of time, we cannot discuss them, but from the general revision that we have done, I'm sure that you have the principles you use to address them. But I want you to be structured, right, in terms of how you lay out your answer. So you take issue, you state the relevant principles, and then you do the analysis and the application. Unless there's a question, otherwise we end the class here. Okay, so I'm happy that any question which will come in this particular area, all of you be able to rise with the occasion and write a very good answer. That is good. So have a good night.